Welcome to the Journal Editorial Report. I'm Paul Gigot. Terror returned to New York City this week with a Halloween Day attack in Lower Manhattan that killed 8 and injured a dozen more. Suspect Saifullah Saipov, a 29-year-old native of Uzbekistan, carried out the rampage with a rented Home Depot truck in a scene reminiscent of Barcelona, Stockholm, Berlin, London, and Nice. The NYPD's counter-terror chief calling it a textbook ISIS attack.
It appears that Mr. Saipov had been planning this for a number of weeks. He did this in the name of ISIS. He appears to have followed almost exactly to a T the instructions that ISIS has put out in its social media channels before, with instructions to their followers on how to carry out such an attack.
Judge Michael Mukasey served as the 81st Attorney General of the United States, and he also presided over the criminal prosecution of the 1993 World Trade Center bombing suspects. Judge, good to have you here again.
Good to be here. You
heard John Miller. This is the kind of nightmare scenario for people who are trying to prevent this. Somebody self-radicalized here, very hard to stop.
Well, self-radicalized is one of those phrases that, frankly, I'd like to bury, because he didn't invent the doctrine.
True.
He didn't create the videos. He didn't create the support system and everything else that goes with it. He was alone in a sense, but somebody who had passed through the radar before.
But what I mean by that is there's not links that would have shown him to have popped up on the screen where the FBI or NYPD could say, aha, he's somebody we need to watch.
Right.
So he just pops up when he murders people.
Right.
So how do you prevent that?
Well, one way you prevent it is, I mean, it's hard to prevent, obviously, somebody who's already here who's intent on doing that. It's not impossible, but it's hard. But you have to get into the support system that he may have had, likely did have. You have to monitor websites that do this, monitor them aggressively. And in part, we have to figure out for example, what extreme vetting really means. What are we vetting for? What we're vetting for is to find people who can't support either the legitimacy or the supremacy of secular law, which is what we have here in this country.
Very hard to do, though, when you're interviewing somebody at the border who in this case, this guy seemed to have been just a regular person in Uzbekistan. And Uzbekistan isn't one of those countries that has been at the top of the list.
I understand that, and he may not have betrayed this when he first came into the country. It was a long time ago. But we need to find people who will not create insular societies to have people live apart and get radicalized. And there are, by the way, techniques and technologies for checking that stuff out. One of them was developed with a grant from DHS, and they refused to implement it because it unduly invaded the privacy of people being questioned.
It seems to me that that's what you have to do, though, because because the border vetting would not, in this case, have worked, or in some of the other cases, the fellow in San Bernardino, that wouldn't have worked. He was an American citizen, so you've got to try to get these people when they seem to be interested in this radical doctrine.
Right, and it takes active pursuit, and it takes acknowledgement and knowledge of what it is you're pursuing.
Okay. He was read his Miranda rights and processed in criminal court right away. Mistake?
Yes. When you have somebody like that in custody, his principal value is not as a defendant. They've got a ton of evidence against him. They don't need his statements.
Right.
His principal value is as a possible source of intelligence. If nothing else, at least to find out what he looked at, with whom he looked at it, if there was anybody else, and so on. That's what should have been the focus, not getting him into the criminal process.
Did you have a protocol in the Bush administration for handling cases like this with interrogation?
I think the protocol was pretty much to get intelligence first. We had a system of essentially a clean team going in and conducting questioning. But even that, I think, was somewhat put together ramshackle.
Okay. Let's turn to the Robert Mueller probe. You saw the indictments this week of Paul Manafort and Mr. Gates and the plea deal with Papadopoulos. What do you make of them? Well,
they are a nice beginning, I suppose, if you're a prosecutor, but they are a beginning. And notably, the deal with Papadopoulos that has everybody's eyebrows going up and down, did not charge him with anything like collusion. He was charged with making a false statement.
Right. Which is kind of the lowest level of prosecution you can have in a case like this.
There's no such thing as collusion as a crime. I mean, you will look in vain in the criminal code to find the crime of collusion. Conspiracy, yes, but not collusion. And
why do you think they didn't charge conspiracy? Maybe I guess they didn't have the evidence that he was conspiring with anybody?
Correct. And what they advanced as the statement of the crime, or the statement of the criminal background, shows that this guy was a kind of a low-level climber who was trying to push his way to the top, talking about how wonderful it would be if Donald Trump went to Russia and talked to Putin. And there's a little footnote in there that says that DT, meaning Donald Trump, doesn't do these trips, and we ought to tell whoever this guy is talking to, we ought to turn him off, and we ought to do it at a low level so that we don't send a signal. Well, that looks like it was something that they thought was a harebrained scheme.
In the Manafort and Gates cases, it seems to me that if those two guys were going to cooperate, they would have cooperated already to get a lower, some kind of plea deal, because Mueller has thrown the book at them. I mean, these are, serious charges with a lot of prison time.
He's throwing a book at them, but not necessarily the book. It doesn't charge. I mean, he talks about a fraudulent scheme, but he doesn't charge bank fraud, which carries a 30-year penalty. He charges simple conspiracy, which carries a 5-year penalty, and labels it conspiracy against the United States. There's no such crime. There's either conspiracy to violate a statute, like conspiracy to violate the bank robbery law or whatever, or there's conspiracy to defraud the United States. There's no such thing as conspiracy against the United States. But it made it sound like treason.
But yeah, he did. But
that's the heavy hand and the empty holster.
So you think the empty holster, you think there may be less here than meets the eye?
There may be more. I don't know. Right. But certainly whatever is there wasn't uncorked in this indictment.
All right. Thank you, Judge. Appreciate it.